Order, all rise.
As court is resumed, please be seated. Good afternoon.
Good afternoon, Your Honor. Your Honor, when we broke for lunch, I was turning to a new topic, and that is the plaintiff's lost opportunities claim. And as I understand the claim, the allegation is that the plaintiffs lost the opportunity to conclude agreements with the Crown to increase the size of the pie or collect more resource rents. And Ms. Evans already went through.
Well, don't they say they lost an opportunity to engage, which might have resulted in those two things, but presumably it could have resulted in other things as well?
That is my understanding of the argument, Your Honor. And Ms. Evans went through the analysis showing that that duty, as Your Honor articulated it, is not found in the stage one judgment or the reasons, and I'll simply endorse that. I agree with my friend's submissions on the point. My intention is to make a few additional comments in response to the lost opportunities claim. And the first point I want to make is that the expansive duty that my friends rely upon would be a profound intrusion into executive function. The form of consultation,
Duty if imposed.
if imposed. And the reason is because the form of consultation that my friends have in mind would require the Crown to justify its policy decisions. And the sort of policy decisions at issue relate to revenue and tax rates. And in our submission, the idea that the government would have to justify how much to tax can't be right. It's a legal impossibility for the Crown to accept legal duties that fetter taxation policy. And in support of that, I'll refer the court to Justice Horrigan's reasons rejecting the fiduciary duty claim in the stage one appeal. And we have that at tab 18 of our compendium.
Go ahead. Paragraph 606.
Paragraph 606 and 607. And Your Honor, Ms. Evans already read these to the court, so I'm not going to do the same. I'll just highlight that the Court of Appeal was clear that it's a legal impossibility for the Crown to prefer the interests of one group over others in making policy decisions. And we say these passages are directly contrary to the lost opportunities claim. Now, I understand my friends to be saying that governments can have their policy decisions. They just have to pay for them through other sources. And that's based on the so-called Carney principle, which the court heard about 2 weeks ago. So I want to drill in on the so-called Carney principle. My friend, Mr. Schachter, referenced Richard Carney several times, but didn't take the court to the primary documents. I would like to do so, and that is in our compendium at tab 20. We have here two letters from Richard Carney to Pennefather from September 1858. But Your Honor, we should first ask ourselves the question, who is Richard Carney? We don't really know is the bottom line. Dr. von Gernot addressed this issue in his testimony, and he could not track Richard Carney's biography. And just for your honor's notes, that's in the transcript, day 26, pages 4313 and 4314. It's testimony from Dr. Von Gernert. Richard Carney was self-described as a commissioner of the UPC, but the nature of his portfolio has been lost to the distance of time. Some sources suggest that Richard Carney was possibly a magistrate. Some say maybe he was a sheriff. We don't really know, other than he was present in Sault Ste. Marie. Now, the point that I want to make about the letters is that it is true that in one of these letters from September 1858, Carney raises the possibility of making up for the difference between the price of land sold and the market price. But if we look at page 128 of our compendium, it's the second page of the first letter.
Just go ahead.
What we see here is that Richard Carney believed that the annuity was not to exceed $4. And this is something, Your Honor, that the Court of Appeal actually talks about expressly in its reasons at paragraph 162. It's the majority reasons. And I don't raise this clearly to challenge stage one findings. It's not my intention. My point is that Carney, Richard Carney, can't be taken as supporting or even suggesting an uncapped obligation to pay cash for public policy decisions. He thought it was only up to $4 per person. And the Court of Appeal noted at paragraph 162 that Carney was basing his views on only having read the treaty. So he cannot be taken as authority for this principle about paying for policy decisions. And I'll turn to my friend, Mr. Schachter's related argument about sparrow justification, because it's related. And as I understand the argument, my friend says that the defendant crowns bear the onus under sparrow, the Queen and Sparrow, to justify their decisions to only collect a portion of resource rents. And respectfully, I say that is flawed, and I'll unpack it. Sparrow justification, as this court knows, is an argument available to the Crown where there's been a prima facie infringement of a treaty. And in the case law, that's usually in the context of the regulation of harvesting rights. It would be theoretically possible to argue that the failure to pay annuities under a treaty in any given year was justified under Sparrow. Theoretically possible. We're not aware of any case like that, and we're not arguing that in this trial. But my friend takes the argument further and suggests that Sparrow requires justification on how much resource rents to collect.
Can I just see if I've got this right? You say the Sparrow justification is an argument available to the Crown where there's been a prima facie breach of treaty?
Right. It usually arises, Your Honor, in the context of harvesting rights. So if there's been a prima facie infringement of a harvesting right through the regulation, say, for example, of hunting, then the Crown can argue this is not absolute, it's justified because these factors are satisfied. And what I'm saying is theoretically, it could be argued, but we're not aware of any case like this, to say that the prima facie infringement of not paying an annuity is justified under Sparrow, but we're not aware of a case like that. But to take it further, as my friend does, is to presume that it's a treaty infringement, a prima facie treaty infringement, to collect anything less than maximal resource rents. So for Sparrow to be engaged in that way, there first must be a prima facie treaty entitlement for the Crown to collect maximal resource rents, at least for resources that are extracted. But there's no support for that in the stage one judgment. And it's inconsistent with Justice Horrigan's findings in respect of public policy. Your Honor, I'll turn to my next topic, which is the future. Future implementation, and that's addressed in our reply submissions starting at paragraph 133. Ms. Evans dealt with this extensively. So my intention again is to simply supplement what Ms. Evans said on the subject.
And adopt the Canada's argument.
Yes.
Thank you.
So my first point is that the detailed relief that's sought in respect of the future in specifically the Appendix A to my friend's factum is unavailable on the evidence. And I'm going to start with what I believe to be an uncontroversial observation. This court's judgment in stage one sets out declarations, obligations on the Crown that are based on either identified legal doctrines or on the evidence of common intention. And respectfully, we say that we see a break from that in the Appendix A document. I'll focus on the requests in respect of a default formula for sharing, which was found at paragraphs 14 and 15. And Your Honor, I'll just note that we have the Appendix A document at tab 21 of our compendium if it's helpful. I don't intend to read from it.
Thank you.
The formula that my friends seek to have imposed is very precise with specific percentages built into it. And as I mentioned this morning, the ethnohistorians in this case gave evidence that there was no common intention to fix percentages. Inviting the court to make declarations not grounded in common intention is, and I say this respectfully, an invitation into error. The second point I wanted to make, Your Honor, deals with the claim for declarations that the court and not the Crown should have the authority to determine how much to share. And that was at paragraphs 7 through 9 of Appendix A. And again, Ms. Evans already addressed this, and I just want to supplement it. We say that the court shouldn't grant a declaration that substitutes itself for the Crown in exercising His Majesty's significant discretion under the treaty. My second point about this relates to locking in the manner and standard of review. Government action, as this court knows, comes in different shapes and sizes. And the proper procedure to review that action depends on the specifics. It might be an application for judicial review. It might be an action. This can't be prejudged as a general proposition for all Crown discretion. And we say that it would be incorrect to lock in either a procedure of review or a standard of review, especially given that the treaty is perpetual. 100 years from now, we don't know what the Courts of Justice Act is going to look like. We don't know what the Judicial Review Procedures Act is going to look like. We don't know what the Federal Courts Act is going to look like. Only the court hearing a future case, whenever that is, could determine the appropriate procedure under statute or whatever else, or the standard of review that applies at that time. And Your Honor, that takes me to my last topic, which is the timing of the judgment. I want to pick this up with the exchange the court had with Ms. Evans on the subject. Ms. Evans noted that the plaintiffs had argued for a wait-and-see approach at the adjournment motion, where additional evidence and submissions could be made after the Supreme Court's reasons. And there was some confusion, as the court will recall, about the language at paragraph 27 of the adjournment endorsement. And I just want to pick up with that discussion. It's definitely the case that the plaintiffs, represented by my friends, Mr. Schachter and Ms. Lewis, argued at the adjournment motion for the wait-and-see approach, which was waiting for the Supreme Court judgment. And the argument was that this would be practical and proportional. And I'm not going to read it, but we have in our compendium, at tab 30, an extract of the written argument on that point.
This is the plaintiff's argument?
This is the plaintiff's argument. And in paragraph 86, it defines the wait and see approach. And then at paragraph 132 to 136, it lays out the practicality and the proportionality of waiting for the Supreme Court. And like I said, I'm not going to read this, but my point is that what's laid out here is basically what we're asking for. Now, I understand that the court is looking for an answer to the question.
It's a new definition of cooperative.
Yes, indeed, Your Honor. Your Honor's question of Mr. Bass and then Ms. Evans was, what would the prejudice be that couldn't be cured by just waiting for an appeal? And in my submission, the issue is simply delay. And I want to be clear, I'm not arguing irreparable harm.
Sorry, I missed the word. The issue is simply
delay. And I'm not arguing irreparable harm. I'm not asking for a stay. I'm clearly not asking for an adjournment. I'm simply pointing out what we say is practical and proportional. All of the evidence of the experts especially, and the arguments in this stage 3 were presented on the assumption that the Court of Appeal reasons remain intact on appeal. Reasons for judgment from the Court of Appeal were quoted in expert instruction letters, as this court knows. It's possible that the Supreme Court changes nothing on appeal. But this is a complex case, and it's foreseeable that there will be at least some difference It might be small, it might be big, between the way that the appeal courts see the case. And we don't know how those changes will impact the expert evidence upon which the opinions were given. If this court releases judgment before the Supreme Court, the only way to address differences in the court's approach to the case would be another trip to the Court of Appeal. But with very limited exceptions, the Court of Appeal does not hear evidence. It's not its function. So an appeal is not the forum to advance new or revised evidence. It's not the forum to ask the economists, for example, how does this change impact your opinion?
I wasn't presuming that when I asked about a trip to the Court of Appeal. I was presuming that on a trip to the Court of Appeal, a party could argue that the Supreme Court of Canada's decision impacts the findings in stage 3, and that should persuade the court to reject the findings or send it back to the trial judge.
Yes, Your Honor.
Not that you would try to present new evidence. You or any party would try to present new evidence to the Court of Appeal in response.
Indeed, and the Court of Appeal would likely not entertain that.
Right.
What would realistically happen in that scenario would be the Court of Appeal would send it back to the trial court under Section 134 of the Courts of Justice Act. And that may or may not be before the same trial judge. It's discretionary. And I'll just point out that in Ms. Evans's discussion of this topic, there was an exchange about functus. And that statutory provision is the answer to that, Your Honor. The Court of Appeal can statutorily send it back to the trial court. What we say is that it's more efficient for the court to remain open, not functus, to receive new evidence or submissions without requiring an appeal. Otherwise, the risk is we spend months getting into the Court of Appeal and then back from the Court of Appeal to the trial court to address the evidentiary points. And we say there's just no need for that.
Tell me again what you see is impractical. You say it's more efficient?
More efficient, Your Honor.
For the trial court.
For the trial court.
What if the trial court thought going to the Court of Appeal was inevitable at the hands of one party or the other?
Well,
I would say, I don't recall it so much in this stage, but it was on the table from early days in stage 1. That was likely, absent a resolution. That was the likely path, which therefore is why I mention it. If that's the likely path, what is this delay, you say, of getting to the Court of Appeal? If somebody is taking you there anyway.
What concerns me, Your Honor, is that we get the Supreme Court reasons.
Yeah.
And they are different from the Court of Appeal in some way. Say, for example, wealth and means, that paragraph changes, right? So that's something that the experts looked at. And then we have the issue. Do their opinions change because of that or not? And if our only mechanism to test that is in the Court of Appeal, what worries me is that the Court of Appeal will say, oh, there are differences. We need to send it back to the trial court. Trial court will finish the job. Then we'll hear the appeal and everything else. That's what worries me. 2 trips to the Court of Appeal are potential. The simpler solution is for this court to stay open. We deal with all of the issues that may arise, wait and see, as my friends would call it. And then if there's a trip to the Court of Appeal, which I don't know, but if there is, then there's just one. That's my concern. But again, Your Honor, I'm not arguing that there's some irreparable harm, because I don't think there is one. I'm not asking for a stay. I'm simply giving our observation on what we say would be the most practical and proportional way of dealing with this very unique circumstance, where this court is hearing a remedies trial in respect of a case where the Supreme Court is currently looking at treaty interpretation issues. So all we're saying is that we're coming full circle to my friend's wait and see approach from November. That's the point of the argument.
Can I ask you this question, which I thought I put to Canada, but I'm not sure I got the answer, and that is, can the Supreme Court of Canada send it back to the trial judge?
Your Honor, I would need to check the Supreme Court Act to answer that question. Well, yeah. So, like, Your Honor, it would definitely be the case that if the Supreme Court allows an appeal from the Court of Appeal, that it could be sent back to the trial court. But what I think Your Honor's question was, could the Supreme Court on the appeal from stages 1 and 2 send this case back, the stage 3 trial back to the trial court? That's what I'm not sure. That's a very unique circumstance.
All right, that's different.
Yes, Mr. Noga is pointing out helpfully that Section 46 of the Supreme Court Act does allow the Supreme Court to order a new trial.
But right, that's on stage 1 and 2.
But that's stage 1 and 2.
I, of course, ask my next question with great respect. Can you make your wait and see argument to the Supreme Court?
Your Honor, I think what that would look like would be us asking the Supreme Court for some relief that impacted the business in the trial court. And that is, as Your Honor knows, something that was in some way visited in respect of the Section 65.1 stay.
No, not that wait and see, not wait to hear it. Wait until they see the stage 3 decision.
Yes, Your Honor. As I understand the question, it would be that the Supreme Court would know what they're going to do, and then the Supreme Court would be asked to make an order in respect of how the proceedings in the stage 3 trial happen. And that's what I'm saying. I don't think the Supreme Court would entertain.
Right.
And we know that from Justice Jamal's order.
Let's speculate that there's a decision from this court within 6 months.
Sure.
That takes us to March. Let's speculate that there's no decision yet in March from the Supreme Court. And I don't know the answer to this. Does it make any sense to ask them to take it into account? Mr. Lipton says no.
Well, then I'll endorse Mr. Lipton's answer. So, Your Honor, the question would be, so we have a decision from this court on stage 3, and then we would ask the Supreme Court to take into account the trial decision from stage 3.
Mm-hmm.
See, that wouldn't be, there are a few issues there. One, that wouldn't be an issue before the Supreme Court under Section 40 of the Supreme Court Act, right? So the Supreme Court gets its jurisdiction from the issues of final decision from the Court of Appeal. So that the stage 3 issues wouldn't be before the Supreme Court statutorily.
I was following your comment that it's good to see the details when you're trying to decide the theory.
Yes.
And they could see what happens with the theory.
I see. Yeah,
but you know, it's out there, but
yeah, Your Honor, I mean, the issue is that the court's findings wouldn't be before the Supreme Court.
I'm not liking this idea.
Very well, Your Honor. Your Honor, that takes me to the end of what I was planning and the 30 minutes I indicated that I'd take. Subject to any questions that the court has on any subjects, those would be the closing submissions of Ontario.
Thank you very much.
Thank you.
Good afternoon, Your Honor. By agreement with Mr. Schachter, I'm going to make my reply submissions on behalf of the group of 7 first. I expect to be about 1 hour, and there are 4 areas that I intend to address. They are the sacred nature of the treaty promise, a reply to the Name-Gusisagegan community submissions, a reply to both Canada and Ontario in their joint positions, and finally, a reply to Canada alone. And that takes me to my first point, the sacred nature of the treaty promise, something that you asked all parties to address. And I start with the Anishinaabe perspective, a perspective that holds that treaties are not everyday pedestrian agreements. There is a spiritual and a ceremonial significance that is infused into the compact. We have seen that in this trial with the inclusion of ceremonies intertwined with the court process. Ceremonies that date back to 1850 and beyond, and were present at the Treaty Council, which itself took place at a location of significance to the Anishinaabe, and that is Bawating. And Your Honor, you discussed the significance of that in your stage 1 reasons at paragraph 214, which I'll ask Ms. Lewis to display on the screen now. And I will remember the injunction against reading quickly.
Never too late to learn.
Yes. The substantive treaty discussion started September 5, 1850, following a pipe ceremony and possibly a smudging ceremony, with all the delegates from Lake Superior and Huron gathered. As Mr. Morrison pointed out, it is important to note that the Treaty Council took place around the Anishinaabe Council Fire at Bawating, Sault Ste. Marie, and not at the King's Council Fire at Manitowoc, nor at the Legislative Assembly or the Executive Council offices of the provincial government in Toronto, nor at the Royal Palace of the Monarch in London, England. Further, not only did the Treaty Council take place at a central and long-standing site of Anishinaabe governance, it was conducted in Anishinaabe-Moan, as well as English, and incorporated ceremonies and protocols that characterize the long-standing system of Great Lakes diplomacy. The location of the Treaty Council, as well as the protocols and procedures followed, indicate that the British, including Robinson, had developed at least a functional understanding of the Anishinaabe systems of law, diplomacy, and language. The point here is that the Anishinaabe were not making a deal with a self-interested stranger. They were entering into a lasting arrangement with the Crown, the Great White Mother. The Crown, a party that had taken on this metaphorical role of parent, or father, or mother in the kinship relationship that they had fostered for decades. As Elder Donio testified, this metaphorical kinship relationship meant something to the Anishinaabe. It meant a great deal. They believed that they would be taken care of. And Your Honor, another way to look at this is from the perspective of what the Anishinaabe were giving up. In this solemn arrangement, they were trading away their exclusive access to and control of their land, something of unparalleled significance to them. They were, as people of the land, trading away a piece of themselves and their relations, of all of their relations. The land was something that held spiritual significance to the Anishinaabe. And of course, I've just quoted Chief Tangi. The Anishinaabe are people of the land. This was spoken about in different but equally meaningful terms by Chief Mashano as the land that his ancestors have always traveled on, and by Chief Tangi as well as a gift from the Creator meant to sustain the Anishinaabe people. But the Robinson-Superior Treaty was an arrangement they entered into as a way to sustain their people, to allow their people to thrive in a changing world, and to pursue Minnow Bamadzuin. It was certainly nothing like an ordinary mercantile transaction in the language that the Supreme Court used in 1895. And nor, I say with respect, was it a deal for the purchase of land. The treaty was a nation-to-nation compact. And while we don't apply the law of international treaties to Canada's treaties with Indigenous people, the use of the term treaty here is telling. It is an agreement that was meant to last far longer than the lifetimes of William Robinson or Chief Shingaquance or Chief Podeshat, or indeed any of the people in this courtroom. It was meant to be perpetual. It was meant to last forever. It was and is the foundation for an ongoing partnership. The parties, after all, were not going to go their separate ways once the treaty negotiations were concluded. They were going to share the land and the future that it provided. The treaty was and is a blueprint for how the Anishinaabe and settler communities can live together. So that, in my submission, is what it means for the treaty promise to be sacred. And based on all of that, the terms of the treaty should be inviolable, never to be broken, never to be infringed, never to be dishonored. But of course, as we have seen, both in Northwestern Ontario and across the country, that has not been the case. That is why breaches of treaty promises create a deep wound in Crown Indigenous relations. And that is why breaching a treaty brings dishonor to the Crown. The breach extends far deeper than monetary consequences that might flow from it. It is also why repairing the wound is so important. Because reconciliation in this country must be built upon repairing these wounds. And not, I say with due respect to those who hold the contrary view, on empty promises. And it is why this court must use all the tools in its remedial toolkit to repair that wound. That is what is required to restore the Crown's honor and put us on a path toward reconciliation. Now, with that, I turn to the second point, which addresses the submissions the court has heard from the Name-Gususagégan community. The Name-Gususagégan community's argument appears to be that the restriction in paragraph 2Q of the intervention order against leading evidence or making submissions in conflict with the plaintiff's agreed upon distribution only applies to stage 3 itself. And therefore, as I understood Mr. Greenberg's submissions, they can contest these issues in what were termed post-decision motions. Now, Your Honor, our reply is this: even if that is accurate, this is an argument for form over substance. It goes against the spirit of this court's order. And it is apparent that accepting the Name-Gususagégan community's argument would require you to decide the community's proper size and potentially whether it or some part of it is even a Robinson Superior Treaty beneficiary, all within the four corners of this litigation. They propose bringing forward evidence to prove their membership in these post-decision motions. And Your Honor, I ask the court respectfully to consider what that would look like. Full-blown hearings with cross-examination on membership, that is on membership lists to establish whether individuals are actually members of Name-Gususagégan as opposed to some other member of the group of 5 or group of 7 First Nations, or whether they are annuitants under Treaty 9, Treaty 3, or the Robinson-Huron Treaty. And in my submission, Your Honor, that's precisely what this court sought to avoid in the intervention motion and the order that ensued. We endorse the proposal that the court raised in questions to Canada that would require Canada to hold Name-Gususagégan's share over and above the appropriate compensation for the group of 5 and the group of 7. And this accords with our earlier submissions that the issue can be dealt with by Canada if Name-Gususagégan establishes that its exclusion was the result of Canada's conduct in refusing to properly recognize members of that community.
I have 2 questions for you here, Mr. Gover. The first is, what do you say to the general proposition from Canada that it is their goal, hope, aim that nations, First Nations or Indigenous people settle their differences amongst themselves? And I take it from that they mean not that this court, therefore, should not make a decision that excludes them. That's the first part of the same question, which is, do you say there is, as a general proposition, that there are processes that would allow those people who say they are members of NAME, who may also be members of other groups, that those are work-outable issues as amongst the First Nation communities or the First Nations? I don't know.
Let me try answering the second question first.
Oh, okay.
And that has to do with other processes. There's a process under the Indian Act for recognition as a band to acquire band status. Inevitably, and this gets to the answer to the first question, inevitably, the determination about band status would play into the or inform the discussions among First Nations about the other issues. But this is a question that I agree with Canada is best dealt with among First Nations. That here is something classically that is best dealt with by way of negotiation. And the First Nations themselves have a wealth of information about genealogies, about traditional territories, and so on. And all of that, in my submission, can be left initially to the First Nations, but the First Nations may need access to the courts. And all of that portends a long process, a process that would conceivably take years, a decade, more. And it takes me to the point that after 173 years, we should not be embarking on a process that would hold up compensation in any way for those who are entitled to it as the law now stands, as history establishes under the treaty. So.
And when you say there are processes, do you say that's the process that is underway?
I understand that.
Understand?
I understand that there is a process underway, and that would determine Name-Gusasagagan's status under the Act, but of course it wouldn't determine the entitlement under the Robinson Superior Treaty, which would be a separate issue. And Name-Gusasagagan, as we know from the motion materials, is comprised of people from different communities, which is part of the complication here. This is a melting pot of Indigenous people from Northwestern Ontario.
You say there are processes for status under which we believe the parties are now engaged, Canada and Name-Gusasagagan.
Yes.
Does that same process or some other process under the Act not also determine whether they're beneficiaries under the treaty? Like, isn't the group of 7 engaged in some process with respect to status as beneficiaries, or is that?
Members of the group of 7 are engaged in a different process. That has to do with their unextinguished Aboriginal title claims. Their status as bands under the Indian Act is not in question and has never been in question.
No, I was asking with respect to their status, their relationship to the treaty. But you say that question of relationship under the treaty is a negotiation on whether to adhere or not.
Well,
in parallel with a claim for unextinguished Aboriginal title.
Correct. I mean, their position is they've never given up their land.
Okay. And unless and until they agree to adhere, they have a claim for unextinguished Aboriginal title.
That's right. That's right. And that distinguishes the group of 7 from others.
So there is no process, for instance, that the group of 7 is engaged in with respect to whether they are beneficiaries under the treaty. The question is only whether they, by some method, choose to adhere or are accepted to adhere.
May I just ask one question? I know it's not normally the role of council. When you refer to they, are we referring to Name-Gusasagagan?
No, I was referring to group of 7.
Well, for the group of 7, of course, it's always been Canada's position and Ontario's position, so far as I know, that they are annuitants under the Robinson Superior Treaty. And the court heard evidence about how, for example, at Big Dagognish Nabeg, annuities were accepted until 1979 and have been declined ever since, with the realization that they may not have been represented at the Treaty Council. Their position, of course, is they weren't represented at the Treaty Council.
So just to get back, and I really didn't want to inquire too much into those processes, but there's a process for the determination of status as a band, but not a process. There's not a specific process
No.
under the Act to determine if one is an annuitant under the treaty.
That's my understanding, and Mr. Schachter, of course, will follow and correct me if I'm wrong, but, and furthermore, I don't know of any process underway involving Namegusa-Sagagan to determine entitlement under the treaty.
And they haven't told us that in their materials.
No.
Thank you.
Thank you. Now, the third area involves my reply to both Canada and Ontario. And I start, first of all, with the calculation of present value and this question about government control over the band trust accounts. Both Canada and Ontario have continued to rely on the argument that the 60-40 approach is inappropriate because of the Crown's historic strict control over what were termed Indian monies in the band trust accounts. And I note that neither emanation of the Crown has sought to defend the Crown's past practice in this regard, but they have essentially argued that this is just the way it was, and we have to live with it, and of course, account for it using a lower bring forward rate. Essentially, they contend that this past practice should work to the Crown's benefit now. It is still unclear how the Crowns are saying that Canada's historic control over different types of money in the band trust accounts would have impacted annuities had they been paid. Mr. Marcello admitted clearly in his submissions that Ontario is not arguing that the annuities would have been Indian money under the Indian Act. And so I'm not sure how Ontario then claims that the annuities would still nevertheless have been subject to the same regime. Ms. Evans was candid that her position on this point was based on speculation. But she still sought to argue that it was somehow likely that the Crown would have decided that they would not pay the annuities to the First Nations in a break from historical practice. She also relied on evidence of Crown officials' concern in the late 1850s about lost investments, which motivated the creation of the band trust account system, which involved holding money in the Consolidated Revenue Fund with a prescribed interest rate. But this referred to money that the Crown was holding and investing on behalf of First Nations, that is, Indian monies. The concern was that if the Crown lost money, it would be expected to still account to the First Nations for the amount. So Crown officers moved the funds into a less risky regime to protect themselves. This doesn't apply to money that was paid out to First Nations and investments they might have chosen to make themselves once they received the money. Now, importantly, neither Crown has even tried to respond to our argument made by Mr. Bass on September 15th that the Crown retaining the augmented annuities would itself have been a breach of the treaty. Here we refer specifically to the language in the treaty that the annuities shall be paid to the chiefs and their tribes. And neither Canada nor Ontario had any answer whatsoever to that point. So the scenario that the Crowns have proposed is not what would have happened in a non-breach world, to borrow a phrase that Canada's counsel used repeatedly. What they are really saying in my submission is simply that they should be responsible for less compensation because had they not breached the augmentation clause, they would have breached a different part of the treaty to keep money from the First Nations. That's inevitably where that argument takes us. And finally, on that point, you heard many arguments from both Crowns about how it would have been unrealistic for the Anishinaabe to have invested in stocks during certain time periods. But I didn't hear any real submissions responding to our argument, rooted in the testimony of the chiefs, that their communities would have used augmented annuities to improve community well-being. And here we're talking about human capital and social investments. They didn't address the point made by Professor Stiglitz that these types of investments have an even higher rate of return than the 60-40 approach. And now I turn to the question of rents.
Could I just go back to one thing, please? I asked the question, I can't remember when, today or yesterday. It was to Mr. Marcello with respect to Indian monies. And you make the point that Mr. Marcello conceded that Ontario was not arguing that the annuities would have been Indian monies under the Indian Act. And my question then as now is it only Indian monies as defined in the legislation that was required to go, or that was able to go, or that was somehow captured and put in the band trust accounts?
I'm going to look to Mr. Schachter for a moment, if I may. And thank you. And thank you, Mr. Schachter. Thank you for the indulgence, Your Honor. The answer is yes. And Mr. Schachter may address this in more detail, but it may be that the example of Six Nations will offer some insight, and Mr. Schachter will comment on that.
Okay. Please just let me make.
Yes. Thank you.
Thank you.
Now the question of rents versus NCRRs, net crown resource revenues. Both Ontario and Canada have referred to the Stage 1 amended judgment to claim that the parties and this court in Stage 1 were only ever thinking about what I'll call NCRRs and not rents. I have a few points in response, really only two. First, the judgment discusses net crown resource-based revenues. This is not an economic term of art. It has an indisputable meaning to all economists. It is a way for the Crown to capture the underlying idea. The judgment expressly recognized that these were general principles to be clarified and refined in Stage 3. And of course, after 60-odd days of evidence and submissions, we know so much more about rents and the economics of resource development than anyone was thinking about in Stage 1. I dare say now, Your Honor, I wasn't here for Stage 1, but I think that might be a safe statement. We've heard evidence from a world-renowned economist and other experts on the subject. And the court, in my submission, can use this wealth of evidence to refine and clarify what the phrase net crown resource-based revenues means.
Did you start out by saying that this term had an indisputable meaning to the economists?
I said it is not an economic term of art that has an indisputable meaning.
Okay, thank you.
Thank you. And second, the judgment does not refer to direct NCRRs. Nothing in the judgment holds that net crown resource-based revenues are exclusive to direct revenues received by the crown, such as stumpage fees, mining profit tax, and water rentals. And notably, the Court of Appeal struck the restriction in paragraph 3B1 of the amended stage 1 judgment on corporate or income taxes. Thus, I say revenues arising from resource extraction that the Crown received indirectly through these forms of taxes are worth considering as a financial benefit that the Crown gained as a result of its access to the lands of the territory through the treaty.
But then we're left with what evidence do we have on taxes?
Correct. Correct. And I know you've heard extensive submissions already on that point, Your Honor. And that takes me to the fourth area that I intend to address, and that is our reply to Canada. And Canada has criticized the plaintiff's position insofar as we seek a result that is the same as if a fiduciary duty existed. We heard pretty much similar submissions from Mr. Rankin today. Canada's counsel point to the fact that the Court of Appeal held that no fiduciary duty exists in this case. And they essentially argue that therefore, the remedies for breach of treaty or breach of the duty of diligent implementation cannot be the same as remedies for breach of fiduciary duty. My point is that it is not necessarily true that a court cannot arrive at the same remedies, whether for a breach of treaty, a breach of duty of diligent implementation, or a breach of fiduciary duty. These remedies are not necessarily the same in every case, but they are also not mutually exclusive. And when I state that as a proposition of law, it calls to mind, and I ask this rhetorically, what else could the Court of Appeal have meant by saying that there's no work to be done by fiduciary duty that can't already be done by the duty of diligent implementation in this case, or by the honor of the Crown in this case, a robust doctrine. And of course, we know now that what Justices Lowers and Pardue said on behalf of the Court of Appeal, well, on behalf of themselves and of course Justice Horrigan, the majority of the Court of Appeal in this case, was reaffirmed by a unanimous court in Chippewas of Nawash. And Mr. Bass took the court to paragraphs 209 to 210 and 292 of the Chippewas of Nawash. My point is, and this is, sorry,
I weren't two of the three authors the same? So reaffirmed by the unanimous court?
well, it was a three-person court. Justice George was with them, and yes,
Okay. So they
It's-
reaffirmed themselves plus one.
correct.
Okay.
But it's how the law has evolved, is my point.
Yes.
And my point is with all due respect to those who would take you to the historical roots of remedies for breach of fiduciary duty, and as interesting as that may have been, the law has moved on. The law has moved on and has recognized the robust nature of the duty of honor of the crown. And it has recognized that there must be a remedy. This takes me back to what I said in the first point. There must be a remedy for these wounds to the Crown Indigenous relationship, the breach of treaty, because of their sacred nature. And we've traced the development now of the proposition that I referred to, that originates with Justices Lowers and Pardue in Restoule, and now encapsulated, as we know, in Chippewas of Nawash. My point is that in Ontario, at least, this must be taken as a matter of settled law. It must be taken as a matter of settled law that, as the Court of Appeal said in paragraph 209 of Chippewas of Nawash, the Supreme Court has over time sustained the principle of honor of the crown for a concept, the fiduciary duty, that in addition to being limited to certain types of relations, did not always concern the constitutional rights of Aboriginal peoples, had paternal overtones. So the law has moved on, and the Court of Appeal has recognized that fact, and that indeed is now the law of this province. This must mean that in the right case, the available remedies can be the same, regardless of whether there's a breach of fiduciary duty, if there's a breach of honor of the crown. We are no longer constrained by labels, is the point. Now, Canada has argued, and we agree, that the remedies for breaches of a treaty must be flexible and responsive to the nature of the duty and the nature of the breach. After all, the remedy is aimed at, as the Court of Appeal put it in this case in paragraph 257, this is again Justices Lowers and Pardue, ensuring the Crown fulfills its treaty promises. So the remedy appropriate in any case is what is required to restore the Crown's honor. And so in certain cases, the responsive remedy may look very similar to a remedy for breach of fiduciary duty. In a case like this, over-reliance on categories like fiduciary duty risks losing track of what is really important in the remedial analysis. And I say with respect that oddly, Canada forcefully argued against strict categorization and formalism in determining the just and appropriate remedies in treaty cases, but then seemed to want to rely on categories and formalism to exclude remedies and principles that would also be available for breach of fiduciary duty. And we ask the court to recognize the inherent inconsistency in Canada's argument in that respect and hold that essentially the remedy must suit the nature of the breach, the nature of the relationship. That, of course, suggests that the remedy will look very much like a remedy that would have been in the nature of equitable compensation.
In particular, would you address the two heads of remedies that Canada seeks to exclude: deterrence and hindsight? You say the law has evolved. The court must be responsive to flexible remedies that the Ontario Court of Appeal has articulated that such flexibility is available to it, and Canada adopts that language, and then Canada, however, falls back on formalism and certain categories to exclude certain portions of that remedy. And you say this court now should not be persuaded by that argument. And can you particularize why any particular head of damage, or as noted, for instance, by Canada, is useful here? Because you don't say all equitable remedies are available all the time.
I don't.
Okay.
But I do say that if we look at the nature of this case and we consider that these breaches date back over 170 years, that there was effectively a loss of insight into what the treaty called for, that here only the individual portion was ever augmented, and that was once in 1875. And we hear submissions such as this was in the nature of a purchase of land. I mean, all of that puts this in the category of a case where the court needs to send a message of some kind. And in my submission, the court should be aware of the broad range of remedies that are available to it. The court can take into account some of the striking aspects of the evidence in this case. And the conduct of Crown officials over the decades really has been egregious. It calls for, in my submission, the court to at least consider imposing some measure of compensation that would reflect the grave nature of the breach, if I could put it that way. So, in other words, it shouldn't be taken off the table.
You're saying not simply the economic calculation.
Correct.
But as you say, the grave nature of the breach.
Yes. Thank you.
Thank you.
And in Canada's submissions, they appeared to conflate the breach of treaty with the breach of the duty of diligent implementation. Essentially, Canada's counsel sought to fold everything under the umbrella of the duty of diligent implementation. And of course, one can imagine why it might be advantageous for the Crown if the court accepted that submission. If everything is about the duty of diligent implementation, that would afford the Crown more flexibility, relying on jurisprudence about how diligent implementation does not need to be perfect implementation. I think you heard more about that even today. This affords the Crown the ability to breach treaties without needing to remedy such a breach, provided that their conduct doesn't amount to a breach of the duty of diligent implementation. We submit that this position is incorrect. A breach of treaty itself can exist independently of a breach of the duty of diligent implementation. So far from conflating the two concepts, we say that they are not the same thing. For example, the Crown may pay money due under a treaty 10 years late. In that case, the Crown will have technically complied with its obligations under the treaty. But its conduct could still amount to a breach of the duty of diligent implementation that may call for a remedy, such as interest for the lost opportunity to use the money in the 10 years. It risks seriously watering down the Crown's solemn or sacred promises to First Nations by permitting breaches of treaty, provided that the more flexible duty of diligent implementation is not breached. And this would actually afford Indigenous people less protection that they would for ordinary commercial contracts, ordinary mercantile transactions, where one can seek remedies for small technical breaches. In this case, there's been both a breach of the treaty and a breach of the Crown's duty of diligent implementation. And I anticipate that Mr. Schachter will be speaking more to that issue. And now I turn to the final aspect of my submissions in reply to Canada. They have to do with the Booth and Kersner model. I preface my submissions by noting that on Friday, Mr. Marcello made it plain that Ontario does not support adoption of that model. So here, Canada stands alone. Ms. Evans sought to deflect some of the criticism that we've leveled against the model, which you'll recall, Your Honor, we did by relying on past jurisprudence, where it has been rejected. Canada sought to deflect that criticism by arguing that the authors of the model had responded to past judicial criticisms and have adapted the model. And Canada points to the fact that now, instead of providing no compensation at all for what they determined to be lost consumption spending, they apply the inflation rate. But well, both Professor Booth and Mr. Kersner did not endorse this idea of use of the inflation rate in previous cases. Canada did propose it as an alternative in both Southwind and Huayot. It was also rejected by Justice Zinn, as we know, in Southwind at paragraphs 487 through 489. And it was rejected by Justice Whalen in the Huayot case at paragraph 321. So the professors adapted their model to address these criticisms by adopting an alternative rate for consumption spending that was also rejected in those cases. I would also point out that Canada did not appear to have any response in relation to the unfair implications of the model that we pointed out. These were the implications that led Professor Booth to admit that he had ethical and moral problems or issues with the model. And that was that different bands would receive different compensation for the same breach based on their historic wealth. Finally, Ms. Evans argued that it is not necessarily a problem with the model, that it is complex, time-consuming, and expensive, as noted in the previous cases that considered it, because, as Ms. Evans put it, if any case can handle the complexity, it's this one. Ms. Evans pointed out that it might be inappropriate in the context of a specific claims tribunal case, which has a statutory recovery limit of $150 million. Whereas she pointed out in this case, the plaintiffs are claiming billions. But this just begs the question of whether the appropriate cutoff limit should be to require, or what the appropriate cutoff limit should be to require First Nations to bring forward expensive, time-consuming, complicated expert evidence to quantify the present value of their lost opportunities. And it may not be clear in advance what the quantum of the loss might be to justify the requirement of such evidence. It is important to remember that even in this case, Ontario's position now is that the plaintiffs are entitled to, at a maximum, around $84 million. My point is that if this court adopts the Booth-Kersner model in this case, it risks creating a precedent that such evidence, with its resulting access to justice problems, as identified in both Southwind and Huayot, becomes required for all claims where Indigenous people seek compensation for historic wrongs. And in my submission, that would be a very unfortunate state of affairs. In any event, we maintain our submission that the model should be rejected because of the numerous flaws that we've already discussed. And with that, Your Honor, subject to any questions, let me thank the court for its unfailing patience and courtesy, and I dare say good humor, throughout the submissions that Mr. Bass and I have made on behalf of the group of 7. Thank you.
Many thanks. Is this a good time for a break?
I think this would be an excellent time for a break, and I'll be able to just start and finish tomorrow.
Very good. Okay. So 15 minutes.
Yes.
This court is stood down for 15 minutes. This court is resumed. Please be seated.
Mr. Schachter.
Good afternoon. During the break, I managed to run off a compendium, which I would ask to be entered as Exhibit QQ.
Well, dare I say, Mr. Schachter, this is quite a bookend. You started in Thunder Bay so
Yes.
long ago. Probably with a compendium.
I did indeed. I wonder if I might, so is that QQ then?
Thank you. Exhibit QQ will be the compendium of the plaintiff's reply. Thank you.
Thank you. Now, obviously, I'm not going to be repeating my submissions in writing or what I did orally already. I do rely on all of that. We also rely on what the group of 7 has written and what they've said already. And I'm just going to be replying to some specific issues that I saw when my friends for the Crowns took the podium. First place I wanted to start is I wanted to address the question of that you asked Mr. Gover about control of Indian or monies from Aboriginal people. Let's call it that.
Am I wrong, or I have often repeated this term Indian monies? Is it legislatively defined term?
Indian monies started to be defined. I'm not exactly sure when Indian monies as a phrase started to be defined.
Okay.
It may have been in 1951. I don't have the exact date. May have been earlier, but your question was really directed to what monies of Aboriginal people never, let's forget about what we call it. What kind of money, this is what I think your question was. What kind of money was required to be held in trust? And the answer, or sorry, required to be held in the band trust accounts and administered by the government. The answer is actually tied up in this notion of responsibility and trust. And it goes back, I believe, to the 1860 Act, an act respecting the management of Indian lands and property. And
Sorry, 1860?
1860.
Okay.
It's a pre-Confederation statute. And it talked about, sorry. I'm actually, perhaps I can just quote from Eric Angel's report. At paragraph 70, he says, from 1860 onwards, a series of statutes and statutory amendments gave officials working for the province of Canada and later the government of Canada control over the management of monies held on behalf of First Nations. So it's almost, that's his statement, but it's not quite, I don't think it was quite correct because it's certain types of monies that are held. And the act, that's why I mentioned the Act of 1860. So the Act of 1860, an act respecting the management of Indian lands and property, what it basically requires is that where you have monies from the sale of lands reserved or held in trust by the Crown, then in that case, the Crown has certain powers in respect of where and how the money is used, invested, excuse me. And the key to that is that what's happening is that the Crown is recognizing that they have control over these funds and they are in effect a fiduciary. And that's why they were so concerned. You might remember Eric Angel testifying. That is why they were so concerned that, oh my gosh, in respect of the Six Nations money, which was a proceeds. So they were selling their land piece by piece and they were getting the proceeds. And they had, prior to 1860, they were not sufficiently within, they were being administered by the government, but not in a certain band trust account. And the Crown expressed this concern saying, we're gonna get sued or we don't like it. We're not doing right by the First Nations when we hold their money. We have this responsibility to them. And so we've got to be careful. But that never applied to annuities is the point. Annuity monies were not the kinds of monies that Canada claimed, or the Crown, excuse me, because it could be prior to 1867, were not the kinds of monies that the Crown had this responsibility to make sure was invested. It wasn't, they didn't have control over it. So they didn't worry about annuity monies. Now, look, in the realm of speculation, of course, maybe had there been an engagement process and a discussion, maybe there would have been an arrangement to do something with the money. Maybe there would have been a discussion, but there wasn't in respect of this case. And the reason that there wasn't does not lie at the feet of my clients. So it's unfair to say, as I think Canada does, and maybe Ontario as well, well, look, come on, everyone knows the money would have been held securely by Canada. No, we don't know that. It's just as likely that if Canada did recognize that it had this fiduciary duty and seeing the massive amounts of money that would come in, they would do something extra special. So it's not fair and not appropriate to suggest that one can know with any degree of certainty in this case that the money would have been held or maintained by Canada. What we do know as a matter of law was that annuity monies were not held by Canada, and annuity monies are not Indian monies.
Did, and forgive me, I can't recall which expert. Did the expert who suggested that the monies would, or was there an expert on the bring forward question, on the present value question, who suggested that the money was likely to be held in a band trust account?
Oh, that's a good question. I don't recall that evidence. I think the closest we have to that is, you might recall at the end of Eric Angel's report, he said that, well, these are like Indian monies. But remember, in cross-examination, he said, I'm not qualified to give that opinion. So, you know, that was neutered, if you will. So no, I don't believe there was there's not any reliable evidence you can rely on to come to the conclusion that the money would have been held by Canada, or on the balance of probabilities it would have been held by Canada. So if that answers that question, I'm going to move on to my notes that I made.
Thank you. Go ahead.
So we maintain, Justice Hennessy, that our clients' treaty rights should be unaffected by the adjustment of the dispute as among the crowns. We have said all along that it should not matter to the plaintiffs whether there's a Section 109 matter involved, a Section 109, 113, 111, 112. It shouldn't matter. But I am faced with the reality that as an officer of the court, I think I want to provide some guidance, if I can be so bold, on what I think the Crown's missed on the issue of constitutional issues as between them. That I think this court, it's an important issue you're deciding, and I don't believe that the Crown's gave you all that you need to do the best job you can of that. And I wanted to identify a couple points, if I might. Neither Crown, first point, in their oral submissions provided the court with any guidance on principles of constitutional interpretation. There are principles of originalism, there's a living tree principle, there's purposeful interpretation, there's things such as double aspect, interjurisdictional immunity, and more lately, cooperative federalism, which I think has given rise to things like the Jordan's principle, if the court is familiar with that. Is the court familiar? Yeah, okay, I'm not going to get into that then. And there is also, in terms of the interpretation of constitutional provisions, and this is from the Quebec secession reference, and I can give you the site, but I'm not going to turn it up. It's 1998 to SCR 217. There's principles of federalism, democracy, constitutionalism, the rule of law, and respect for minority rights, including Section 35 Aboriginal and treaty rights. So when you do your work to decide what 109 and 111 and 112 means, you're going to have to go into all of those principles of interpretation to try and sort out what the constitutional provisions intend. Secondly, Ontario's assertion, which they made a number of times, about the Constitution being the only port of call for creditors of the old province of Canada, I I believe to be wrong. Ontario asserts this at paragraph 239 of their main submissions. And at that paragraph, you will observe there's actually no cite for that assertion. They assert it, but there's no cite for it. Respectfully, Ontario's argument on this point is a conclusion that they ask the court to draw. It is not a good statement of the law. And I say that their proposition fails for a number of reasons. Section 111 makes Canada liable for the debts and liabilities of each province existing at the Union. It does not say that Ontario or the province are not liable. An augmented annuity obligation that is based on productions of the treaty territory in, say, 1869, post-Confederation, is arguably not a debt or liability existing at the Union. Now, if you can turn up in my compendium to the very first tab, there's a little bit of a historical anomaly that I guess that I had alerted the Crowns to this, but I think both Crowns, but I take it they didn't think it was important. I think it is for your consideration. And that's the history of the legislative history of 109, what is now 109, 110, 111, and 12. And so we can go to the London Conference of 1866, and you'll find the sections I want to turn up are at tab 1, page 5 of the compendium QQ. And I'll wait for you to get there because we'll go along together.
Thank you.
So I've yellow highlighted paragraph 55. 55 and 56 eventually get brought together in a way in section 109. So if you look at 55, it says all lands, mines, minerals, and royalties, and it then goes on. That looks familiar to section 109, right? But if you just want to compare it to tab 2, just flip over. You'll see that section 109 has some additional verbiage in it, which I've highlighted in yellow, which is about all sums then due or payable. Now, where does that all sums then due or payable? Flip back to the London Conference, 1866 on page 5. And if you look at paragraph 56, there's a clause that says all sums due from purchasers or lessees of such lands, mines, or minerals at the time of union shall also belong to the local government. And so that section 56 actually disappears in the final draft. And instead you have the reference to all sums them due or payable. And then if you go over again back, just trying to compare the differences. If you look at paragraph 59 of the London Conference, it says the general government shall assume the debts and liabilities of each province. So it's an unrestricted assumption of all liabilities and debts of each province. And for whatever reason, and it'll be for you to make of what relevance this is, that eventually became section 111, and it's no longer just a reference to all the debts and liabilities of the province. It's those existing at the union. So to the extent that that's a difference, you should keep that in mind. The second reason So, so the second portion of the problem with Ontario's analysis of section 109, 111, and 112, I think it wrongfully assumes that the intergovernment reconciliation of accounts also addresses the liability to the plaintiffs. And keep in mind that we've just gone through the very sections that speak to ownership, beneficial ownership of the lands of Ontario, and it also speaks to Ontario or the province's rights to the proceeds of monies, sums due from purchasers or lessees. But what's missing from this intergovernmental relationship is a statement saying, and Ontario is liable or Canada is liable. So it doesn't say in 56, which we became 109, that Ontario is liable in respect of those assets. And then it goes on at what is now 111 to say Canada shall be liable for the debts and liabilities of each province existing at the union. And the question,
You said paragraph 56,
or 55 and 56 get
Yeah.
merged into 109.
you say it does not say that Ontario is liable with respect to those assets, those at the land that,
It doesn't, right? And I'm like, that particular statement works in Ontario's favor, not Canada's. And 111 then says Canada shall be liable for the debts and liabilities of each province existing at the union. And the question is that supposedly legislating that Ontario is not liable? Is that supposedly legislating that only Canada is liable? Or does it in fact, in the proper context, really speak to an intergovernmental discussion as between the various crowns? I say it's the latter, but this is something for you to decide, and you should be aware of these discrepancies in the legislation as it was developed. Likewise, Ontario's argument on the division of powers and reliance on 9124, I think, confuses the constitutional division of powers with the responsibility to act and fulfill treaty terms. And for that, I just thought it might be useful. I just pulled up the case of Daniels and Canada. Daniels in Canada had to do with.
Mr. Schachter, I'm
Yes.
sorry.
Oh, I'm sorry.
Something you said, and I looked to the transcript, and so did the stenographer. You say, likewise, Ontario's argument on the division of powers and reliance on.
9124.
Thank you.
My apologies. Confuses the constitutional division of powers with the responsibility to act to fulfill treaty. And I was going to the Daniels case, which had to do with the interpretation of 9124. And there's perhaps the longest head note I've ever seen. But if you go to paragraph 13 of the decision, I'm going to tell you where you can find that. You can find it on page 23 of the compendium, tab 3. And it had to do with whether the federal government had legislative authority over Métis and non-status Indians. And the Supreme Court says paragraph 13, as the trial judge found, when Métis and non-status Indians have asked the federal government to assume legislative authority over them, it tended to respond that it was precluded from doing so by 9124. And when Métis and non-status Indians turned to provincial governments, they were often refused on the basis that the issue was a federal one. So this political football or ping pong, if we can call it that, hasn't stopped in this case, in the case of Daniels. We see it in this case for the last 173 years. Paragraph 14, Justice Phelan of the federal court, I guess the Supreme Court of Canada summarized it this way. This results in these Indigenous communities being in a jurisdictional wasteland with significant and obvious disadvantaging consequences. And that was, and Justice Phelan actually referred to the political football. Over on page 15 of the decision in yellow highlight, the Crown had argued that, look, just because we have jurisdiction under 9124, even if we did, there's no obligation to legislate at all. And the court went on to grant the declaration, but we must remember, and the reason I wanted to cite the case is because there is not a duty or a responsibility to legislate simply because you have the power to legislate. So we can only take that so far. So there's problems with using 109 to say that only the federal Crown has obligations, and there's problems using 111, 112 to say only the Crown has direct responsibility. So if 9124 and section 111 operate such that Canada is liable, is the only one liable directly to the plaintiffs, then Canada has sole jurisdictional authority and sole constitutional authority to effect a constitutional promise, the treaty promise. Now, Ontario, with respect, in its zeal to win the day in this court, has neglected to consider, I think, the consequences of its position. If Canada, and Canada alone, has the responsibility to ensure, in accordance with the honor of the Crown, that there is a future sharing of the productions of the treaty territory in a manner so as to ensure that there is a sharing of future opportunities and future potential of the treaty territory, then we might end up down the road in a federal paramountcy problem where the federal government is going to dictate Crown extraction policies to Ontario in order to best honor that treaty commitment. Now, we've seen something like this happen in the National Energy Program of the 1980s. You might recall that Alberta was very much upset that the federal government was dictating through energy policies and interfering with their resource base. Now, I don't believe that Ontario was intending in its argument to, they would never agree with that, of course, but the court should be mindful that that could be the consequence of what they have wished for. As for Section 109, if Section 109 governs who is liable directly, it would be on the basis that the plaintiffs have a proprietary interest in the lands or in the proceeds of the lands. At least that's the law now. If that's true, then I think it inevitably follows that Ontario gets turned into an express trustee, and it would mean that no use of resources can effectively take place without Anishinaabe consent. Now, from an Anishinaabe perspective, while that might be welcomed, I don't think the court wants to make the decision you're going to make on 109 and 111 without at least considering that as a consequence. The alternative, to say that a Section 109 interest does not have to be a proprietary interest, but can be something less, has some appeal to it, but I think it would be contrary to precedent. And I just wanted to make that point clear, because I mean, it was my first impression that perhaps that's a reasonable place to go. But I just want the court to be aware of a couple cases, and I can deal with it very quickly. The first case is Delgamuke from 1997, Supreme Court of Canada, found at tab 4 of my compendium, page 31.
Just let me catch up, please.
Yep. Delgamuke, 1997. Delgamuke, DELGAMUUKW, spelt as it sounds.
Thank you. Oh, were you turning to it?
Yes, I'm turning to page 31 of my compendium. It's just one excerpt of Delgamuke, paragraph 175, where Justice Lemaire, the Chief Justice at the time, quotes from section 109 and makes the following observation. Referring to section 109, that provision vests underlying title in the provincial crown, in provincial crowns. It qualifies provincial ownership by making it subject to any interest other than the province in same. In St. Catharines Milling, the Privy Council held that Aboriginal title was such an interest. So Aboriginal title itself, unextinguished Aboriginal title, is a section 109 interest. Go over to the next tab at page 32, tab 5, excerpt of Guerin and the Queen. Justice Dixon at paragraph 88 identifies, he repeats the St. Catharines Milling case determination that the Indian interest was an interest other than that of the province within the meaning of section 109 of the Constitution Act. He repeats section 109. And then at paragraph 89, when the land in question in St. Catharines Milling was subsequently disencumbered of the native title upon its surrender to the federal government by the Indian occupants in 1873, the entire beneficial interest in the land was held to have passed because of the personal and usufructory nature of the Indians' rights. And then a couple other cases, one other case on that, and he ends the paragraph, upon surrender, the right disappeared in the process of release. And so we at least have now the situation where, as I understand the law, a surrender releases the proprietary interest. Now, maybe the Constitution should be interpreted so that the interest doesn't have to be a proprietary one. That'll be for you to decide. But what we say is that the proper answer is not through 109 or through 111, but it is through Grassy Narrows. And I've already referred to Grassy Narrows, and the principle, and the court is familiar with it. I just observed that more recently, I guess it's Mikisew Cree from 2018. If you'll take a look at tab 6, consistent with the long line of history going back to 1895 in the Supreme Court of Canada, 1896 and the Privy Council in this case, in respect of this treaty. It only feels like I've been litigating this case that long. Justice Karakatsanis said, she said, I accept that these are valid concerns. It is of little import to Aboriginal peoples whether it is the executive or parliament which acts in a way that adversely affects their rights. The relationship of Aboriginal peoples with the Crown or sovereign has never depended on the particular representatives of the Crown involved. And again, that's just reiterating the idea that it shouldn't matter to the Aboriginal litigants who shouldn't matter to the Aboriginal litigants who they made the agreement with, who they made the bargain with, who they made the treaty with. It is a compact, sacred with the Crown, and that should be enough.
Okay, so what's the next step? Let's say it doesn't matter to the plaintiffs.
Yes,
So you bring the question to the court as between the crowns,
yes,
and one crown says it's section 109, one says it's 112 and 111, and you say the answer is it doesn't matter to the plaintiffs.
it should not matter. I mean, if it does matter, if our rights are in any way compromised by a determination one way or another, then it does matter. But I'm inviting the court to rule that it doesn't matter, and that the proper adjustment as between the crowns is found in Grassy Narrows, and that when I say it shouldn't matter, the way it shouldn't matter is that they're both jointly liable. If I didn't close that loop, right? That's how it won't matter to us, if they're both directly liable, and we say that they are. And we say that they are because of Grassy Narrows and the jurisdictional capacity to affect the promise.
And you say they're both directly liable.
Yes.
And I think Canada says that as well and asks the court to fix a percentage. So as opposed to saying jointly liable for 100%, they say, well, they both have a direct liability, but a specific percentage liability.
Yeah, that would be wrong in law because this is not a several obligation. Now, the several there's only one obligation to pay. There's not two obligations to pay. There's only one annuity that is to be calculated to be augmented, not two. We can't have Ontario looking at its expenses and revenues, and then Canada looking at its expenses and revenues, and then the two crowns coming up with different answers or different suggestions on implementation. There's only one correct answer here, and that's if there are productions from the treaty territory that permit the Crown to pay an increase, it shall be paid. Not a matter of discretion at all. And so we say that it makes a lot of sense if you want to ensure that as I think you should, that the plaintiffs are not affected by the intergovernmental disputes that rage on amongst my friends. Make them jointly liable for this one obligation. It's not a several obligation, it's one obligation. And as between the two of them, apportion liability as you wish or as might be appropriate, whether it's 20% for Canada or 100% for Ontario. As between the two of them, they can continue to fight it out as long as they wish. But if we can go to either of them to have our rights fulfilled to the extent that it's within their jurisdictional competence, I accept that. But we say in our argument, there's nothing in the Constitution that limits their spending power. That's number one.
Sorry, before you get there,
Yeah,
you say it's not a several obligation, but
that's right.
it can be apportioned, 2080 or?
Sorry, it's not a several obligation, but as between the crowns, it can be apportioned. So not a portion, the liability of each joint wrongdoer would be in respect of 100% of what's owed to us. But as between the two wrongful actors, they can either agree that they're going to be 50-50 or can come to court and say they should only be 20-80 or 100-0.
Well, that's what they're doing right here.
Yes, and you should decide that. But that's an apportionment
Well, that's on the
between,
cross claim, you say.
yes, that's an apportionment between them. It would be wrong to force the plaintiffs to only go to one port of call or to go to two different ports of call if there was an apportion, as if there were several liabilities, because there's not several liabilities. There's only one joint obligation here. Does require both crowns to cooperate. It does require the sharing of information, and it requires an engagement process, but it is an obligation of the crown to the plaintiffs.
Thank you.
If the court has that point from me, I would move on to, I think I have time to make this point before the break. Canada, in their argument at paragraph 289, relies on a case called Good versus Toronto Police Services Board, 2013 ONSC 326. It was a case, I wonder, can I borrow that case? Canada, it's from Canada. I forget which tab it is. I had it marked in our book that I left in somewhere else. But as you're looking for it, I think I can just go from memory. What Canada did is they relied on a paragraph of Good versus Toronto Police Services Board for the proposition, they said, that joint and several liability, thank you, is a concept involving private law that's unique to law of torts and private contracts and doesn't apply to public law matters. We say that Canada's reliance on this case is not as good for them as they might think. Firstly, and at issue in that case was an alleged charter breach brought by individuals against police officers, and on which the plaintiffs argued that the state should automatically be liable under the principles of vicarious liability in tort. And you'll see that what the court in Good did was rely on a statement from the Supreme Court of Canada case of Vancouver and Ward. And what I have done is I've excerpted the very paragraph that, paragraph 22, that the court in Good relied upon. And I think it's important to sort of really understand that what the court was talking about, both in Good and in Ward, was this idea that vicarious liability has no place in public law conceptions. And of course, that makes good sense. You can see that from reading what Justice McLaughlin, then the Chief Justice, had to say. And at paragraph 22, she wrote, "The term damages conveniently describes the remedy sought in this case. However, it should always be borne in mind that these are not private law damages, but the distinct remedy of constitutional damages." She then refers to a Thomas J. in a New Zealand case dealing with the New Zealand Bill of Rights, where that judge said, "An action for public law damages is not a private law action in the nature of a tort claim for which the state is vicariously liable, but a distinct public law action directly against the state for which the state is primarily liable." A line later, Justice McLaughlin continues, "The nature of the remedy is to require the state or society writ large to compensate an individual for breaches of the individual's constitutional rights. An action for public law damages, including constitutional damages, lies against the state and not against individual actors." So what the court in Ward is telling to us is that governments are not liable to individuals based on vicarious liability, but that liability must be direct. It is the conduct of the state that is brought into question. It is the conduct of the Crown in this case that is brought into question. We're not talking about the conduct of one individual. We are speaking to and addressing, in this case, the conduct of the Crown. The court's reference in good case to joint and several liability not having any relevance in the public law realm is one, obiter, because the decision is about direct and indirect liability. Three, is obiter because the decision is about direct versus indirect liability, not joint liability directly. Secondly, a good case is a charter case. It is not a treaty case. Thirdly, joint liability is not a private law concept. It describes an incident of how a party could be directly liable and nothing more. Fourthly, treaty rights are not just public law rights, but unquestionably have an element of private law in them. And the analogy to charter rights is not particularly apt. I see we are at 4:35. I could go to some small issues or just wait until tomorrow.
Well, let me know how tomorrow looks, please.
I think I do not need to press the day today to finish tomorrow.
Thank you very much. Then we will break for the day and reconvene at 10. And we'll go off the record for just one brief moment.